Hello and welcome to the Patent Pending Made Simple podcast. I'm your host, Samar Shah, and with me is Jamie Brophy and a special guest. Jamie, how are you?
Hey, Summer. I am good. I am excited to be recording another episode today, and I'm excited about our special guest. We're going to be interviewing a patent paralegal, Hastings Galloway. I work with her quite a bit. She is my go to person, like if I have questions about deadlines or petitions, stuff like that. Hastings always knows the answer. So she's really helpful. We're going to talk a little bit about like what a patent paralegal does and some of the like formal requirements for filing a patent application. So we're happy to have Hastings with us today. Welcome, Hastings.
Well, thank you, Jamie and Summer. I'm happy to be here and looking forward to discussing the ins and outs of the patent world with y'all and the listeners.
Yes,
Yeah.
Hastings, thanks so much for being on the show. And I must say that Hastings, you've been one of the best patent paralegals I work with. We've been working for 4 or 5 some years, and I am so glad that we do because I would be completely lost in my practice without having your help and guidance on so many things. So thank you for joining us. I think this will be an amazing masterclass for those who are listening because there are so many times where inventors ask me questions and I'm like, I don't know. Got to ask Hastings on the show.
Well, thank you, and I'm happy to help.
Yes.
So, Summer, do you want to kick us off with the first question or should I get started?
Yeah, let's do it. So, Hastings, can you tell us a little bit about yourself? The audience has heard from Jamie and I quite a bit, but if you can introduce yourself, I think that'd be very helpful. And then we'll go from there.
Wonderful. Thanks. Well, my name's Hastings Galloway. I've been working in the patent field, the patent world for 12 years now. And it's actually an industry that I kind of stumbled upon. I was working in hospitality in the food and beverage industry for a lot of years after graduating from Florida State with my international affairs degree that was also not being used at the time. But I was actually offered to help out a family member with a large client intake, and that happened to be at a patent law firm here outside of Washington, D.C. in Northern Virginia. And I slowly but surely built my patent knowledge and job skills through basically an internship there. And I was able to take an online course for my paralegal certificate, which helped immensely. But I must say, it was working with the staff and the lawyers there at that firm that really gave me such a great basis and knowledge for the field and the workings and ins and outs of what it meant to be a paralegal. And ever since then, I've been doing it and loving it and helping inventors and companies have their dreams come to fruition.
That's pretty cool. It sounds like it was mostly like kind of on the job training. You learned most of what you needed to learn just by kind of doing. So, with your paralegal certificate, is it just like a general certificate or is there like a specific one for patent paralegal?
It was a specific one for the patent field. Patent law, to my knowledge, is vastly different from most other practicing law. Just, I think, and correct me if I'm wrong, isn't it the only type of law that when you become a patent lawyer, you have another master's in another field, such as electrical engineering or civil engineering? It's very different, and the minutia of it, I think, is what makes it kind of interesting and a harder field to get into. Not harder, but just maybe a little bit more specific than other law.
Yeah, just different, right? Yeah.
Yeah.
Well, cool. So, what would you say are like some traits or qualities that make a good patent paralegal? I mean, I know from my experience with you, you're just like very organized and you're very like on top of deadlines. But what else do you think? Like, what are some other skills that come in handy for a patent paralegal?
I believe probably the number one skill or trait to have in this field is your attention to detail. The minutia of patent law and filling out the forms that are required when filing a patent application are very specific. And one tiny little mistake could end up costing clients or the inventors lots of money down the line if they're not caught in the beginning stages of patent prosecution. So I would say I'm one of your best defenses as far as making sure that those mistakes are found or corrected and going over things with a fine-tooth comb before they're actually submitted to the United States Patent and Trademark Office. So attention to detail would be probably my number one as far as what you should try to have in the field. And then, of course, organization. There's so many deadlines associated in patent prosecution and patent law, and just being able to stay on top of that and make sure that you make your attorneys and your clients, inventors, companies aware of the deadline, getting that the cost known to them and their permission to move forward before things happen. So there's a lot to keep up with for sure.
Yeah, definitely. I mean, I think
They,
those are both great ones. Sorry, Summer, go ahead.
no, no, go ahead, Jamie.
Oh, yeah, I was just going to say,
Yeah.
like, for Summer and I being like the patent practitioners, I mean, attention to detail that's a big one for us as well. And despite our best efforts, sometimes we miss stuff. So it's really nice to have you as like a backup to double check stuff. And there are times when you've come back to me and said, hey, did you mean to say this? And I'm like, oh, yeah, thanks for catching that. So, yeah, I definitely appreciate your attention to detail in your organization. So I think those are both great ones. So, Summer, sorry I interrupted you. Go ahead.
No, no, that's exactly what I was going to say. Hastings, you just have an incredible skill of having that attention to detail, staying on top of multiple projects. Because, we as attorneys or practitioners, we will zoom in and out of projects, right? So, like when we're working on a project, we are usually knee deep in that project. And it's almost like we have blinders on for a couple of hours, couple of days, whatever the project scope is. Then it's really hard for us to look at our entire docket. And that's where you come in and you're able to look at the whole landscape and say, hey, you have this coming up. Do you have this on your radar? Is this done? Hey, where are we with this? All of those things, I really appreciate it. So I think you have a great skill for that. But a lot of our listeners who are listening are inventors, right? And they may work with a patent law firm and they may work with patent paralegal, right? Like that's a big part of a paralegal's job and responsibility. Could you maybe just walk us through what your day looks like or what a typical patent paralegal's day would look like in terms of interacting with clients and interacting with attorneys? And then I'll have a follow-up for you after you're done. And I'll ask, how can clients work more efficiently and effectively with you, the paralegal specifically, as opposed to the attorneys? So yeah, if you can give us a quick overview on what a day in the life looks like, I think that'd be helpful.
Okay. Well, first of all, it takes an enormous amount of coffee pretty early in the morning. Get me going and to keep me maintaining that level. But I think the docket, which is to those out there, is where we keep and track all of their due dates and the application specifics within a software that usually the firm has. That's so important. That's kind of like we live and die by the docket. Due dates are generated by that. And so one of the first things that I'll do every morning is pull that up and just see what the day looks like, what the week looks like, 2 weeks out, even a month. And looking at that, you get these important dates. And then the number one, a big part of my day is to alert the client and the attorneys about due dates with a nice outlook on it. Usually, if something is due in 3 months, I will report it out when it comes in. Let's say, such as office actions, non-final office actions, final office actions from issued by the USPTO. And we send those reminders in a timely fashion. Report right away, and then there will be a 2-month follow-up, a 1-month follow-up, a 2-week even, just to make sure that we're all staying on time with things. Because even though the PTO does allow some extensions of time for response to things to keep costs down and everybody in the know, it's always nice to try to hit those deadlines as soon as possible. And then once I go through that and send out all my reminders, make sure there's no deadlines for that day, I will start to receive emails or actions from the attorneys for filings for the day. And that's anything that needs to be documented or filed in the USPTO to move along the prosecution of the patent. And then also just reporting out those actions when they're done to the client, because that's very important. The inventors and the clients, I'll use those as two meanings or two of the same. We want to make sure that you know what's going on. I mean, this is your baby, your invention, and just to keep you in the know as much as possible. It's always good to let them know exactly when anything happens with their patent. And then from there, it's cleaning up the docket, going through emails, and just staying on top of everything in general to make sure we have the best timely outcome possible for your invention.
That makes a lot of sense. Yeah, those are so many responsibilities. It's just mind-boggling to me that you are able to stay on top of it as well as you do. And this is why you're so good at what you do. But yeah, so I think this is super helpful for hopefully our listeners. Sometimes I am sure our clients get emails from you, Hastings, or from a paralegal if they're working with another firm, for example, and they're like, well, why isn't my attorney emailing me, right? Why is a paralegal emailing me? And sometimes I even get that from clients. They're like, hey, I want to talk to the attorney and not the paralegal. And I'm like, hey, if this deadline is important to you, you should be talking to my paralegal. So what would you say to the listeners of the show in terms of how to develop effective communication with the paralegal? If you send them an email or call them about something, how can they make sure that process goes efficiently from your end, from your perspective, and make the things go? From my perspective, I will say this, that the clients who are nice to our paralegals and keep them informed tend to have a much better outcome, because then Hastings will be like, hey, this person so-and-so called me. Are you on top of this? Are you checking this? And that always helps, having an extra layer of accountability and follow up and feedback.
Absolutely. And I love some of the client relationships that I've been able to develop over the years. I mean, I know people on first name basis now. I get updates about their kids, sometimes Christmas cards. So it is important. We're all working together in this. And as far as, feeling like you need to talk to a lawyer about specific things, I could speak for myself. And I think most paralegals will very much let you know if that's above their scope of knowledge and will pass that question or contact attorney to get in touch with you. But the things that paralegals are going to be looking for specifically are really just general knowledge about the inventors and the companies that you may want to list in your invention or ownership of your invention. And just making sure when we ask for that information, that's important for the declarations, the assignment, the power of attorneys. We call these formal documents. And while obviously the paperwork and the application, the specification, claims, drawings, all that is very important in the patent world, so are these formal documents, particularly the declaration, which, if not filed in a timely fashion, it will cause your application to become abandoned. So when asking for this information from you, it's very important to provide the most thorough, your first and last name, your legal first, last, and name, full legal name. You might not want to use Bobby. You might want to say Robert if that's how you're identified on your identification information. And also your company too, making sure, is there a comma after your name and then LLC? How is that provided on your legal paperwork for your organization? Just little things like this, again, the minutia of it all, can really hem up the process in the patent prosecution, and even particularly so if you decide to foreign file your patent application. Some countries can be very particular, and if there's one little comma off or your name is slightly represented differently from the US application versus the foreign application, even like your middle initial being dropped off in the process, it can really cause problems down the line. So it's just giving us the best, most detailed information possible when we ask for this requirements for the formal documents.
Yeah, I think that's a great point. So making sure that you're giving your paralegal accurate information, thorough information, and responding in a timely manner. I think all of those things help all of us that are involved in the process. So yeah, I think that's a great point, Hastings. And it goes back to that attention to detail that we were talking about earlier in our conversation. And that brings to mind, like, we recently had a client that filled out all the paperwork we asked for, and they misspelled one of the inventor's names, unfortunately. And we had to go back and fix that. And between the USPTO fees and the amount of time that the paralegal spent on it, that misspelling mistake ended up costing our client like $250 to correct. And that was just a name misspelling. So it's important to get all that information correct. Make sure you're getting all the correct information to your paralegal. So you already talked about it, but like, what are some of the formal documents, or I guess what are the required formal documents that need to be filed with a patent application? And then what are some like like additional formal documents that might need to be filed with a patent application?
Well, besides the application itself, some documents that I'm responsible for, the declaration, which will be signed by each inventor responsible for input on an application. That's probably one of the most important and one that the inventors will actually have interaction with because they will have to sign that document, whether it's a wet signature, meaning that you print that paper out, use an actual pen and ink, and scan it back into your law firm, or we have a handy e-signature now, or an online auto signature through like a PDF or a sign now, some kind of filler like that. And then there's what's called an application data sheet, which is probably the most important, declaration being right under that. Although inventors don't really have a hands-on process with this besides providing that very detailed information to myself or your paralegal to fill out. And that's going to, again, name all your inventors. And then you have a city of residence, city, state, and country of residence, and then a mailing address. And you list that all out. And then that's also where you can name a company to be included in the ownership of the application, another very important part of the process. And those two documents are really what is required by the USPTO for filing a non-provisional patent application. And then two other documents that are pretty important and we file very regularly would be a power of attorney. And that's going to give your attorney that you've chosen power to file and maintain your patent in the Patent and Trademark Office. And then also there's an information disclosure statement and known as an IDS. And that is basically your patent bibliography. Anything that you use to gain knowledge about your patent or maybe reference to it, that would be included in this information disclosure statement, the IDS. And there's four different sections, four different ways you can list your items in your bibliography. You can reference other patent numbers, other patent publication numbers. Then you have foreign patents that can be listed out, and also non-patent literature, like any kind of articles that you've gathered online. You can cite websites as well that have been helpful to you. And that's really important to include that information to your attorney and paralegal. And that'll help give the patent examiner a little bit of a basis on how this came about. And also then it won't be used against you in an argument as well in an office action. Is that correct in me saying that?
Well, no, I'm glad you brought up the information disclosure statement. I think that's definitely an important part. So the inventors have a duty to disclose anything that they're aware of that might pertain to their application. So yeah, Hastings, like you mentioned, any patents that are similar or that can be used as background information or any websites or anything like that that they're aware of that might have features similar to their invention, it's important that they disclose those. Examiner can use them in an office action, but where the inventor would run into a problem is later on down the line. That's a good source for invalidating a patent, is if somebody's aware of something and they didn't disclose it in an information disclosure statement, then the patent could possibly be invalidated later on if they're able to show that the inventor knew about these things but didn't disclose them in the information disclosure statement. So yeah, that's a great point. The only other document I can think of is maybe like an assignment where they would assign their patent rights to a company. Do you want to talk a little bit about that, Hastings, or are there any other documents that you file sometimes?
Yes, the assignment's important. Again, that's only used if you are including a company, and all inventors must sign their rights over to this company. So you need to have that agreement with everyone that you've created this application with. That's important. That's filed through, it's run by the USPTO, but it's considered a little bit separate from the actual filing process of the patent we use in a specific assignment branch. But very important, particularly too, if you are going to foreign file your application. A lot of countries require an assignment if you list a company in your application. So that is important. And then I guess entity status. we haven't really touched upon, right?
Yeah, that's a great point as well. Yeah, so you can file as just the standard filing as would be considered a large entity, or you can say you're a small entity, or you can say you're a micro entity, and that just determines like what fees you pay at the USPTO. So, yeah, do you want to talk a little bit more about the entity status, Hastings?
Yes, and this is not I know some about it, but as far as how having to establish it, I might have to run the numbers, but I know if you are like a solo inventor, a startup possibly, we use micro entity status a lot, and I think it's broken down by two different categories on how you can claim micro. Isn't one gross income, and then the other is educational base, and I know that one is I've used I don't even think I've ever filed one with the educational base before. But the micro entity status is really, it gives people who might be a little bit more cost effective or cost conscious in filing this invention. And I don't know the specific number for the median household income, but it is a great tool to figure out if you do fall within this category, because you can cut your patent costs down by, gosh, was it a fourth of what it is for large entities? Is that correct?
Yeah, it's something like that. So, yeah, I mean, the micro entity, the gross income basis one, if your income's under a certain level, then you qualify for micro entity. And yeah, the USPTO fees are quite a bit less if you're a micro entity. So, yeah,
Which
no,
is,
this could.
yeah, great for solo inventors and
Oh, yeah.
people who aren't large companies. Yeah, it's basically, it gives everyone a chance to be able to file a patent application. You don't have to be Apple or some big organization out there to get your invention patented. You can be a solo inventor at home.
Yeah, definitely. Summer and I should probably do like a whole separate episode on like entity status to determine whether you're small entity or micro entity. But yeah, that's a great one to bring up. Summer, I'll give you a chance to chime in here. Did you have anything to add to that or any other pressing questions for Hastings?
Yeah, so I think this was a great overview. I'll say this. So this is a lot of paperwork, right? Hastings that you're working with and dealing with. And it may feel like a lot of paperwork also to clients, right? And inventors. They're just like filling out information and they're like, I don't understand why the patent office needs so much information or why the law firm needs so much information. I'll say this, that we need it. The law firm needs it because the patent office requires it, right? That's all the information that we're collecting usually. But just to bring this down to earth a little bit, and Hastings, I'd love to ask you your war stories as well. But one of the ones that I remember is when we had a client, when we started the patent process, signed his name as Junior, right? Like Roy Wood Jr. And then when the patent was allowed a couple of years later and we were getting some additional documents signed and submitted, he forgot to include Junior, right? And I didn't think much of it. I just forwarded the email to you and we're like, yep, let's get this document submitted, pay the issue fee, and bam, the patent will get allowed. And you were like, oh no, there's a Junior missing, right? Because that's a wrong person at this point, right? If you don't have that,
Yeah.
that patent would have been in jeopardy because the client hadn't signed the paperwork and paid their fees until like a day before, 2 days before the deadline. And if we had submitted it without the Junior, the patent office would have rejected that piece of paper, and that patent application, instead of being allowed, would have become abandoned, right? Which is a huge, like some of these things clients may think, oh, what's the big deal? But some of these can have huge implications for your patent application. So to me, that always stands out as like a huge one that like you averted potential catastrophe, right? And I'm really thankful for that. I'm sure the client was really thankful for that. But yeah, if you have any other war stories to give the listeners some idea as to the implications, I think that'd be very helpful too.
I guess just one more little piece of advice or request. Again, like Summer said, when we ask you this information or specifics on where to sign, where to date, what not to add to things, please adhere and listen, because it is only in your best interest. And if I come back and ask you to cross the T or dot an I, it's only for you and the benefit of your patents and your pockets. Because you can usually get out of things, but you're going to have to open up the purse to do so. So we're all just trying to work together here.
Yeah, exactly. So, yeah, Hastings, I think the one other thing we wanted to go over is post-allowance. So, we've talked a lot about the papers that need to be filed kind of along with the patent or along with the patent application or at some point while the patent application is pending sometimes. But once a patent gets allowed, we get that notice of allowance. We have a period of time where we have have to pay the issue fee after we get that notice of allowance. I know you have a checklist that you go over before we pay the issue fee or before that patent gets issued, just to make sure that everything's in line before the patent issues. Can you talk a little bit about some of that stuff that's on your post-allowance checklist?
Yes, absolutely. One of the big things that I do reach back and ask the client about is whether their entity status is the same now that the patent has been allowed. Sometimes people's income obviously can fluctuate within the about 2.5 years, 3 years the patent prosecution goes through. So if that has changed, it's very important to go ahead and change that entity status with the before the filing of the issue fee. Also, to make sure that the maintenance fees that are filed after the patent is issued will also fall under that new income bracket. If not, you could lose the rights to your patent if somebody challenges you and finds that you have been using the wrong fees for your patent. Just going through the notice of allowance itself and making sure everything is correct. Did the USPTO list out the right claims that have been allowed? Was there an examiner's amendment? Did we approve that amendment? Has the client approved that amendment? Has an assignment been filed with the PTO? If so, did we get the notice of recordation? Is that also listed in the applicant information for the patent as well? Very important, because this can mean your application is abandoned even if it's been allowed and you pay the issue fee. Have all the inventors signed and dated the declaration for submission. You have up until the day you pay the issue fee to make sure that those are all in order with the USPTO. It's something that we like to do way before the fact, but there's been instances where I've had other clients accidentally pay the issue fee and one of the declarations was not filed and that came back as abandoned. They abandoned the application afterwards. It's always fixable. Again, it can just cost you some money and some time. You look at the docket to make sure all docketed action up until that notice of allowance had been completed. Another one, making sure that the formal drawing have officially been accepted. So just to hurry up the process with that, that's usually done within the first office action that issued during prosecution. They'll have a box that's checked that says, yes, the formal drawings have been accepted. And then lastly, just making sure if you filed an information disclosure statement, the IDS, any of them in the prosecution lifetime of the patent, just making sure that the examiner has gone through and has checked off and entered all of those references cited. And I believe that's about it.
Well, that's a lot.
Yeah, I skipped a couple of ones were just really very much in detail, but those are some major ones that I would say that you really need to make sure it happens. There's also, talking about government funding. Has there been a non-publication request? I mean, it really does get into very much detail, but the declaration, the IDS, assignments, all the paperwork looking in order, those are your main ones. But it's about a 3-page document that then goes through, make sure everything been correct.
Wow. Well, thanks for doing all that. We appreciate it. Yeah, I'm glad you mentioned the entity status because that reminds me of a case you and I think, had recently where when we filed his application, he really wasn't making very much money. And then his invention was successful and made kind of over the income limit for micro entity status. And we forgot to ask him, or I don't know what happened during the prosecution of the application, but we didn't realize that his income had gone up so much. And then before the application got allowed, we double checked his entity status. And he's like, oh, no, I'm not micro entity anymore. I haven't been for some time. So we had to go back and remit all those fees. Remember that?
Oh, yes. And that's, again, it's fine and it's fixable, but it really is. Yeah, when we ask you things or questions are posed, the best information and fairness you can be with us is what we need so we can do the best job for you. And yeah, I'm glad that was caught. And then we were able to file that continuation application in right order with the right entity status. And yeah, it was a good save for sure.
Yeah, absolutely. Well, I think this has been really helpful, Hastings. Summer, do you have anything else to add or any other questions for Hastings?
No, I think this has been super helpful. And yeah, it's so much stuff that you got to stay on top of, that we're really grateful, Hastings, to have you do all these things and be super thorough with it. It makes our job easier, makes our lives easier, and it gives our clients such a better outcome. So it's been really great, certainly having you and helping us, but also all the information that you gave us on the podcast today. I think it's super helpful, hopefully to our listeners as well.
Well, thank you. This has been such a pleasure, and I enjoy working with both of y'all as well. You make my job easy.
Well, thanks, Hastings. We appreciate your time today.
Oh, thank you.
Yeah, thank you.
All right, Samar, we'll talk next time. Thanks.
Yes, thanks everyone for listening.
Thank you for joining us on the Patent Pending Made Simple podcast. I hope you enjoyed our show. If you'd like to receive updates, view the show notes, or access a direct link to any resource, go to the episodes page on patentpendingmadesimple.com. To help others find our podcast, please like, share, and subscribe. Thanks again for tuning in. I look forward to having you with us next time on Patent Pending Made Simple. This podcast has been hosted by Outlier Patent Attorneys and is not intended to, nor does it create, the attorney-client privilege between our hosts, guests, or any listener for any reason. The content of this podcast should not be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.